It was the year 2020, and the DPP of the ACT had brought not one but 4 prosecutions of a man named UD. They were in the Supreme Court of the ACT, ACT-SC, each proceeding called the Queen and UD. The prosecution of interest to you and me was the Queen and UD, where the DPP of the ACT was prosecuting UD for aggravated burglary and other offences related to UD's alleged misadventures at the Lanyon Vikings Club. That's also in the ACT, in 2017. Aside from the break-in, theft and stolen car, UD was said to have broken the pokies, and whilst his takings were a miserly 15.15, the damage to the machines tallied an unfortunate jackpot of over $150,000. Anyway, back to the DPP of the ACT v UD in the ACT-SC in 2020. The trial of the Queen v UD was due to commence in April 2020. UD wanted trial by jury, enter COVID-19. In an effort to combat COVID-19 in the ACT, the Parliament of the ACT passed the COVID-19 Emergency Response Act 2020 ACT. That Act inserted Section 68BA into the Supreme Court Act 1933 ACT. By Section 68BA1, the section applied to a criminal proceeding against a person for an offence against a law of the ACT if their trial was to be conducted during the COVID-19 emergency period. Critical was Section 68BA3. It empowered the court to order trial by judge alone, TBJA, if satisfied the order would A, ensure the orderly and expeditious discharge of the business of the court, and B, that it was otherwise in the interests of justice. What that meant was no need for UD or the DPP of the ACT to agree to TBJA. With 68BA in force and UD's trial due to start ASAP, UD's trial judge, Elcom J, contacted the DPP of the ACT and UD to say, FYI, I'm thinking I might use 68BA and order a TBJA in the Queen v UD, thereby giving notice under 68BA4. Well, it seems the DPP of the ACT was like, OMG, and UD perhaps gave out a WTF. Soon, both the DPP of the ACT and UD were asking Elcom J not to make an order under 68BA3 to mandate a TBJA over UD's objection. But Elcom J was worried. With COVID-19 preventing trial by jury for the foreseeable, His Honour observed that it was not in the interests of justice to have innocent persons languishing in prison, awaiting trial, being denied justice. The DPP of the ACT did not seem to share that concern, nor it seems did UD, who would rather have languished in prison and be denied Elcom J's version of justice, a speedy TBJA, than suffer the injustice of a TBJA to which he did not consent. UD decided to challenge the validity of 68BA, saying it offended Chapter 3. So UD issued a 78B. The AG of the ACT promptly intervened under 78A to defend the compatibility of the provision with Chapter 3. So the DPP of the ACT and UD opposed an order for a TBJA under 68BA3, whilst the AG of the ACT insisted at least that 68BA did not offend Chapter 3, and TBJA could properly be ordered without the consent of UD or the DPP of the ACT. Elcom J focused first on whether he would use 68BA3 to order TBJA for UD, because only if he did would the validity of 68BA under Chapter 3 arise. Elcom J found that if COVID-19 meant jury trials were NA, then the interests of justice favoured a TBJA unless the unique circumstances of the case suggested otherwise, or an accused could not have a fair TBJA. So Elcom J asked himself whether UD could still have a fair trial if it was TBJA, and whether a jury possessed any particular advantage in this case. This meant a Supreme Court judge was tasked with judging whether a jury would be better at judging UD's guilt than a judge such as himself. The judge adjudged that they would not, noting that the Queen v UD was really an ID case, and that to prove ID, the DPP relied primarily on DNA and CCTV. But the judge went further. He adjudged that not only were there no particular issues that would make a jury's judgment more suitable, a judge's applications of the rules regarding ID could make for a judgment favourable to UD. Having so judged, the judge gave the parties another FYI. I'll order a TBJA under 68BA3 if it turns out 68BA does not offend Chapter 3. Consistent with his preference for collective decision-making, UD decided he wanted more judges, HCA judges, to be the judge of 68BA's compatibility with Chapter 3. Using Section 40 of the Judiciary Act 1903, UD sought removal of the constitutional issue to the HCA. In April 2020, a judge of the HCA, Gordon J., adjudged that the constitutional issue ought to be judged by 7 judges of the HCA-FC. They would judge the Supreme Court judge's judgment and the judgment of the legislature of the ACT as to who should judge the issue of UD's guilt in light of the COVID-19 emergency, and UD's judgment that he would prefer to be judged by a jury rather than a judge in a TBJA. The matter was removed to the HCA and became C7-2020. More 78Bs were issued, and other AGs intervened under 78A in support of the AG of the ACT. That is to say that 68BA complied with Chapter 3. A hearing date was TBC. In C7-2020, 3 questions were stated for the opinion of the HCA, representing the 3 bases on which UD argued that 68BA offended Chapter 3. The first was that it was invalid because it offended the Cable Doctrine. That is, does 68BA offend Chapter 3 because it so undermines the institutional integrity of the ACT-SC that it would render it an unfit repository of the exercise of the judicial power of the Commonwealth as contemplated by Section 77(3). UD thought so in at least 3 ways. 1, UD contended trial by jury for offences tried on indictment, absent accused election for TBJA, is itself simply a defining characteristic of a Supreme Court. 2, that the terms of 68BA were itself tantamount to impermissible enlistment of the court by the Parliament, so that its defining quality of being independent and impartial was compromised. And 3, that 68BA required the court to depart to an unacceptable degree from the processes which characterise the exercise of judicial power in criminal trials. In his second ground for challenge, UD invoked limits said to reside in the Self-Government Act of the ACT. The reference in Section 48A to the Supreme Court of the ACT was said to have adopted the constitutional conception of a Supreme Court as used in Chapter 3. And that conception, UD maintained, precludes the trial of an accused for an indictable offence without a jury unless he or she consents to it. On the same basis, UD said Section 22 does not empower the legislature of the ACT to authorise TBJA without accused consent. Finally, UD said 68BA was invalid because it offends Section 80 of the Constitution. UD argued Section 80, which mandates trial by jury for all trials on indictment for offences against the laws of the Commonwealth, had direct application to offences against the laws of the ACT. Acceptance of this submission was going to require the court to overrule its 1915 decision, the Queen and Bernasconi. Ultimately, a judge of the HCA adjudged that there was not enough certainty that UD would have his guilt adjudged by a judge, and that the ACT-SC judge may yet adjudge that his judgment ought to change given the changing COVID situation, and ultimately judged that UD could be judged by a jury rather than a judge. On that basis, the order for removal to the HCA was revoked. The HCA judge's judgment proved correct, with the ACT-SC judge judging that a jury could, after all, judge the accused. The net result was that no one needed to judge whether the judgment of the Parliament of the ACT to empower judging by judges alone, even when an accused judgment is that they would prefer to be judged by a jury, was a judgment constitutionally available to it. That judgment can await another day. So for now, you be the judge. Would 68BA offend Chapter 3, even during COVID-19? Or is your judgment that forced TBJA for trials on indictment against the laws of the ACT are okay, especially in 2020?